What's up, everyone? This is your host, Ghost, coming to you live with another wonderful video. How is everyone doing today? Let me turn that on. There we go. How's everyone doing today? We got a few things we're going to talk about. All right, hold on. Just verified my audio was good. All right. We got a few things we're going to talk about today. Obviously, the Supreme Court ruled to keep Trump on the ballot. The correct decision, regardless of how angry people are. But yeah, of course they were. Of course they were going to. Like, come on, was this really actually ever an actual option? Like, I thought that it wasn't going to be ruled this way. Of course, the state can't prevent a president from running for office by removing them from the ballot. Of course. Of course. I don't understand why this was so surprising, but it is for some reason. Sorry. But yeah, so that was the ruling. It has driven leftists mad. They're calling for the disbanding of the Supreme Court. Because you got to disband or interfere with the Supreme Court because they don't rule the way you want them to. And because they don't rule the way you want them to, they need to be out. That's the basic basis of why they want to remove the Supreme Court. They didn't rule the way that we wanted them to, therefore they need to leave. Now here's the thing: this was a really good decision considering the fact that it was 9-0. That was the decision, 9-0. So 9 of the justices voted, no, you can't have Trump on. State can't remove Trump off the ballot. So that should really tell you all you really need to know how bad this decision was. Or not decision, but this action was, I guess, is a more accurate term. So yeah, there's that. And then after we finish with if we finish with the Supreme Court stuff, Nikki Haley won the DC primary, and everyone is acting like it's the greatest. It's so awesome, and it's the turning tide. She's won one primary out of how many? Actually, I'll Google that later. But everyone's like, "Oh my God, this is amazing! It's she's winning. She's going to completely change. Everything's changing now. She's in the lead. Well, whatever. They're like so over this, which is hilarious. I don't understand why. She's won one time out of how many? Really? But anyways, that's what's going on. So we'll get into that a little bit, maybe. And then COVID is now the flu. The CDC has now advised people to treat COVID as the same as the flu and drop the 5-day quarantine. Interesting. Kind of seems like something we've been saying for a while. Now they're saying it for whatever reason. So we'll get into that. And then last, but certainly not least, you're going to watch the greatest political ad of all times. And I mean, regardless of where we get to, we're definitely going to watch that political ad today. All right. So if I got to go a little over, because I'm going to read the full opinion from the Supreme Court on Donald Trump versus Anderson. So this may take a while, and I may not get to the other subjects, but regardless, we're gonna watch this political ad because it is fucking awesome. I love every minute of it. and it's gonna like like you know who this guy's on without him actually saying it if you don't know who he is. All right. Without further ado, make sure before I get into it, let's do this a little house cleaning. Make sure you follow me on official or on follow me on X at official W Ghost. That is the best way to find out when I go live, hear my opinions. I've been tweeting a lot about this stuff because, why the hell not? I've been arguing with people. Um, the funniest thing I got to say is no one, no one, no one can answer me a simple question of who who's been charged with an insurrection. They keep calling it insurrection, keep calling Trump an insurrection, but no one can tell me who's been charged and or convicted of insurrection because there isn't anyone, so it's not really an insurrection. Um, let's see what else. What else? Okay, of course. Follow me on Rumble, rumble.com/withghost. That is my number one platform. That's where I'm going to be till the end of time. As long as I'm streaming, I will definitely be streaming on Rumble. Let's see. And speaking of Rumble, guys, I want to look this up. It's still a really good time to buy Rumble stock. Um, Rumble is really making headways in their in becoming a new platform to be used. Logging in to tell you how much. But Rumble is still making their way into being their the son of a bitch. Sorry. Rumble is doing great things. They keep getting more and more people, and it seems like every time you look at Rumble, they're doing something new. Their platform's coming better and better. So now's a good time because eventually Rumble's going to shoot up. It really is. Currently, Rumble's stock is $7 a share. So that's pretty good. It's really good. It's not too bad, honestly. But eventually, the stock's going to go up, and it's going to be a pain in the ass to try and buy. So if you get a chance, just go and buy some Rumble stock. $7. Come on, $7 on a platform that's doing so well. It's getting so many deals. I don't know what else to say. But anyways, yeah, check me out on Rumble. And then, of course, twitch.tv/officialwithghost. And then youtube.com/withghost. I don't know that I'll actually get you to my page. But, I don't fucking know. But again, if you follow me on X, you'll definitely find me. And then, of course, check out Coffee Brand Coffee. That is by far my favorite coffee company of all time so far. Although Rumble apparently has their own coffee. I think it's called 1776. I may be trying that here pretty soon. Anyways, but at the very least, check out Coffee Brand Coffee. In my opinion, it is by far the best coffee I've had. I'm very upset still that they discontinued my favorite flavor, which is French toast. Maybe they'll bring that back next time I order, but fortunately, it's not back now. But my referral link and my coupon code GHOST, they're both in the description below, so check that out. All right, I've spent way too long on this intro, so let's get into it. So we're going to start with, like I said, as promised, the opinion. Now, this is 20 pages long. It's not super long, but I may stop and have an opinion here and there, so this may take a bit. We don't know. So let's get into this. All right. So per curiam, and I don't know all the legal terms, so I will be mispronouncing a lot of the legal terms. Do not judge me because I am not a lawyer. I work for a living. All right, per curiam. This is basically what it looks like to me is the background of the whole thing. This is the background. So let's look at the background. A group of Colorado voters contends that Section 3 of the 14th Amendment to the Constitution prohibits former President Donald J. Trump, who seeks the presidential nomination of the Republican Party in this year's election, from becoming president again. The Colorado Supreme Court agreed with that contention Now, I don't know if they'll mention this, maybe not, but they use the civil standard of which is preponderance of the evidence, 51%. So they use the civil was it civil a civil God damn it, whatever it is. Basically, they found Trump like they ruled Trump in as inciting an insurrection, which is why he's invalid in their opinion of Section 3 of the 14th Amendment. But they use the civil metric, which is 51%. All right, so continue. It ordered the Colorado Secretary of State to exclude the former president from the Republican ballot in the state and to disregard any write-in votes that the Colorado voters might cast for him. Former President Trump challenges that decision on several grounds because the Constitution makes Congress rather than the states responsible for enforcing Section 3 against federal office holders and candidates we reverse. So yeah, I don't know why like all leftists really thought that states had this ability. And people specifically on the Twitter keep saying, oh, the Supreme Court is hypocritical. It's states' rights, state rights, but on this, it's not state rights. Well, they don't really understand that the stuff they've talked about that are state rights, whatever their ruling is, or when they rule in favor of states' rights, it's because what they're talking about, like say abortion, that the Roe v. Wade, that only affects the individuals in that particular state. Doesn't affect anyone else. Doesn't really have any national blowback because it only affects the individuals in those states, and those individuals in those states can go to another state and exercise those same, the abortion that they want. While it comes to removing a candidate from the ballot, that has effects nationwide. So, excuse me. And that's why this particular thing, removing a candidate from ballot, is not a state right issue, and it has to be made by, done by Congress, not the states. Because it's a nationwide thing. You remove a candidate from the ballot, disenfranchising the voters of everyone in the nation. All right. Last September, about 6 months before the March 5th, Colorado primary election, 4 Republican, 2 unaffiliated Colorado voters filed a petition against former President Trump and Colorado Secretary of State Jen Griswold of Colorado State Court. These voters, whom we refer to as respondents, contend that after former President Trump's defeat in the 2020 presidential election, he disrupted the peaceful transfer of power by initially organizing and inciting the crowd that breached the Capitol as Congress met to certify the election results on January 6, 2021. One consequences of those actions, the respondents maintain, is that former President Trump is constitutionally ineligible to serve as president again. Their theory turns on Section 3 of the 14th Amendment. Section 3 provides, no person shall be a senator or representative in Congress or elector of president and vice president, or hold any office, civil or military, under the United States or under any state, who have previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same or given aid or comfort to the enemy thereof. But Congress may, by a vote of 2/3 of each house, remove such disability. Meaning that if a person wanted, could petition Congress to, hey, I want to run, this is why, and Congress could vote, and if they get 2/3 in each house, that, being prevented from holding any of these offices that disability would be removed. Now, again, this is clear. It says holding any office, not running for any office. According to the respondents, Section 3 applies to the former president because after taking the presidential oath in 2017, he intentionally incited the breaching of the Capitol on January 6th in order to retain power. He claimed that he is therefore not a qualified candidate, and that as a result, the Colorado Secretary of State may not place him on the primary ballot. See Colorado View Stat Section 1-1-113 parentheses 1-4-1101 parentheses 1-4-1201 1-4-1203 2A 1-4-1204 2023. After a 5-day trial, the state district court found that former President Trump had engaged in insurrection within the means of Section 3, but nonetheless denied the repetitions petition. Again, this was a civil standard that they applied. I'm kind of disappointed that they didn't mention that. Like, using a civil standard, they determined this. The court held that Section 3 did not apply because the presidency, which Section 3 does not mention by name, is not an office under the United States, and the president is not an officer of the United States within the meaning of that provision. Seeing appendix, I think that means to PET for cert 184A-284A. In December, the Colorado Supreme Court reversed affirmed by a vote of 4-3, reversing the district court's operative holding. The majority concluded that for the purpose of Section 3, the president is an office under the United States, and the president is an officer of the United States. And what's interesting is we'll see what Supreme Court goes on this, because this is blatantly incorrect. The president's not an officer of the United States, and the presidency is not an office under the United States. So this is really incorrect. So we'll see whether the court actually goes into this, or they just say they just ignore that and say, no, this is why this doesn't apply to the president for this reason. Let's see how far they go with this. Or let me talk. Say yes, we agree with the district court's whole thing, and the question is whether they would go into it of Section 3. Oh, I guess this is actually correct. Oh no, we'll see. Sorry, I'm like letting my thoughts stream. Let's see. The court otherwise affirmed, holding one, that the Colorado election code permitted the respondent challenge based on Section 3.2, that Congress need not pass implementing legislation for disqualification under Section 3 to attach. 3, that the political question doctrine did not preclude judicial review of former President Trump's eligibility. 4, that the district court did not abuse its discretion in admitting evidence portions of a congressional report on the events of January 6th. 5th, that the district court did not err in concluding that those events constitute an insurrection. They did. And that former President Donald Trump engaged in the insurrection, and that 6, that former President Trump's speech to the crowd that breached the Capitol on January 6th was not protected by the First Amendment. It was CID at 1A-11-4A. The Colorado Supreme Court accordingly ordered Secretary Griswold not to list President Trump's name on the 2024 presidential ballot or count any write-in votes cast for him, ID at 11-4A. Chief Justice Boatwright and Justice Orr and Birkenkotter each filed dissent opinions, ID at 11-5A-124A, 125A, 161A, 162A-183A. Under the terms of the opinion of the Colorado Supreme Court, its ruling was automatically stayed pending this court's review. CID at 11-4A. We grant former President Trump's petition for certiorari, which raised a single question. Did the Colorado Supreme Court err in ordering President Trump's excluded from 2024 presidential primary ballot, C601 US 2024, concluding that it did, we now reverse. All right, so now this is going to be the history. So they reversed. They have reversed. Whew, a lot of word salad for all that. Proposed by Congress in 1866 and ratified by the states in 1868, the 14th Amendment expanded federal power at the expense of state autonomy, thus fundamentally altering the balance of state and federal power struck by the Constitution. Seminole tribe of FLA versus Florida, 517 U.S. 4459, 1996. Also, see also Ex parte Virginia, 100 U.S. 339, 345, 1880. Section 1 of the amendment, for instance, bars the states from depriving any persons of life, liberty, or property without due process of law or denying to any person the equal protection of the laws. And Section 5 confers on Congress power to enforce those prohibitions, along with the other provisions of the amendment by appropriate legislation. Section 3 of the amendment likewise restricts state autonomy, but through different means. It's designed to help ensure an enduring union by preventing former Confederates from returning to power in the aftermath of the Civil War. C, e.g., CONG, Globe, 39th COG, First Session, 2544, 1866, Statement of Representative Stevens, warning that without appropriate constitutional reform, yelling secessionists and hissing copperheads would take seats in the House. ID at 2768, Statement of Senator Howard, laminating prospects of state legislatures, made up entirely of disloyal elements absent a disqualification provision. Section 3 aimed to prevent such a resurgence by barring from those who have once taken an oath to support the Constitution, afterwards went into rebellion against the government of the United States. Congress, Globe, 41st Congress, First Session, 626, 1869, Statement of Senator Trumbull. Section 3 works by imposing a certain individual preventive and severe penalty disqualifications from holding a wide array of offices, rather than by granting rights to all. It is therefore, as Chief Justice Chase concluded and the Supreme Court itself recognized, to ascertain that particular individuals are embraced by the provision. APP to PET for Cert 53A, quoting Griffin's case 11F, case 726, number 5815, CCVA 1869, Chase Circuit Justice. Chase went on to explain that to accomplish this ascertainment and ensure effective results, proceedings, evidence, decisions, enforcement of decisions, more or less formal, are indispensable. ID at 26. For its part, the Colorado Supreme Court also concluded that there must be some kind of determination that Section 3 applies to a particular person before the disqualification holds meaning. APP to PET for Cert 53A. The Constitution empowers Congress to prescribe how those determinations should be made. The relevant provision in Section 5, which enables Congress, subject, of course, to judicial review, to pass appropriate legislation to enforce the 14th Amendment. See City of Bowen v. Flores, 521 U.S. 507, 536, 1997. Or as Senator Howard puts it at the time of the amendment was framed, Section 5 casts upon Congress the responsibility of seeing to it for the future that all sections of the amendments are carried out in good faith. Congress, Globe, 39th Congress, First Session at 2768. Congress Section 5 power is critical when it comes to Section 3. Indeed, during a debate on enforcement legislation less than a year after ratification, Senator Trumbull noted that notwithstanding Section 3, hundreds of men were holding office in violation of its terms. Congress, Globe, for the 41st Congress, First Session at 626. The Constitution, Trumbull noted, provided no means of enforcing disqualification, necessitating a bill to give effect to the fundamental law in the law embraced in the Constitution. I bid the enforcement mechanism Trumbull champion was later enacted as part of the Enforcement Act of 1870, pursuant to the power conferred by Section 5 of the 14th Amendment, General Building Contractors Associations. Aston Inc. versus Pennsylvania, 48 U.S. 37538 1982, C16 Stat 14 143-144. Case raises questions whether the states, in addition to Congress, may also enforce Section 3. We conclude that states may disqualify persons holding or attempting to hold state office, but states have no power under the Constitution to enforce Section 3 with respect to federal offices, especially the presidency. In our federal system, the national government possesses only limited powers. The states and the people retain the remainder. Bond versus United States. I'm gonna dear Lord, so much fucking. I'm not gonna read all this extra stuff, the numbers and shit. I'm just gonna read the title. So save my mouth some pain. Among those retaining powers is the power of a state to order the processes of its own governance. Alden versus Maine. In particular, the state enjoys a sovereign power to prescribe the qualifications of their own office and the manner of their elections, free from external interference, except so far as plainly provided by the Constitution of the United States. Taylor versus Beckham. Although the 14th Amendment restricts state power, nothing in it plainly withdraws from the state this traditional authority. And after ratification of the 14th Amendment, states use this authority to disqualify state officers in accordance with state statutes. See Worthy versus Barrett and State Ex Rel. Sadlin versus Watkins. Such power over governance holds does not extend to federal office holders and candidates because federal officers owe their existence and functions to the unite voices of the whole, not of a portion of the people. Power over their election qualifications must be specifically delegated to, rather than reversed by, the states. U.S. Term Limits, Inc. versus Thornton. But nothing in the Constitution delegates to the states any power to enforce Section 3 against federal office holders and candidates. As an additional matter, not even the respondents contend that the Constitution authorized states to somehow remove sitting federal office holders who may be violating Section 3, such as a power would flaunt the principle that the Constitution guarantees. Such power would flaunt the principle that the Constitution guarantees. The entire independence of the general government from any control by the respective states. Trump versus Vance, 2020, quoting Farmers and Mechanics Sav Bank of Minneapolis versus Minnesota. Indeed, consistent with the principles, states lack even the lesser power to issue writ of mandamus against federal officers or to grant habeas corpus relief to persons in federal court. See McClung versus Silman, Tarbell's case. The respondents nonetheless maintain that states may enforce Section 3 against candidates for federal office, but the text of the 14th Amendment on its face does not affirmatively delegate such power to the state. The terms of the amendment speaks only to enforcement by Congress, which enjoys powers to enforce the amendment through legislation pursuant to Section 5. This can hardly come as a surprise given that the substantive provisions of the amendment embodies significant limitations on state authority. Fitzpatrick versus Bitzer. Under the amendment, states cannot abridge privileges or immunities, deprive persons of life, liberty, or property without due process, deny equal protection or deny male inhabitants the right to vote without thereby suffering a reduced representation in the House. See Amendment 14, Section 1 and 2. On the other hand, the 14th Amendment grants new powers to the Congress to enforce the provisions of the amendment against the states. It would be incongruous to read this particular statement as granting the states the power, silently no less, to disqualify a candidate for federal office. So basically, let's see what I got from this is what they're saying is that the 14th Amendment basically restricts state rights, and it doesn't make sense that it restricts states, autonomy and states' rights and gives a little more power to the Congress. So it doesn't make sense that while restricting and depriving states' rights, that this particular section would end up giving more rights to the state, because according to them, the 14th is all about really restricting states' rights, not giving more state rights. So basically, they're saying it doesn't make sense that this amendment it doesn't make sense that this particular amendment would give states the power to disqualify a candidate from office when it spends the entire amendment, constricting it. The only plausible constitutional source of such a delegation as the Elections and Electoral Clause, which authorize states to conduct and regulate congressional and presidential elections, respectively, see Article 1, Section 4, Clause 1, Article 2, Section 1, Clause 2. But there is little reason to think that these clauses implicitly authorize the states to enforce Section 3 against federal office holders. Granting the state the authority would invert the 14th Amendment's rebalancing of federal and state power. Just want to see. Let's see. Okay. So Section 2, and shit, that doesn't help actually. Oh, Section 2, Article 1, Section 2, Clause 2 says each state's appoint in such manner as the legislator thereof may direct a number of electors equal to the number of senators and representatives to which the state may be entitled in Congress, but no senator or representative or person holding an office of trust or profit under the United States shall be appointed an elector. Okay. So that's Section 2. That's Article 2. Okay, and then Article 1, Section 4, Clause 1. The time, place, and manner of holding elections for senators and representatives shall be prescribed by each state by legislation thereof, but Congress may at any time by law make or alter such regulations, except as places of choosing senators. I think that's meant to say choosing. So there you go. That's basically saying, these are just those are just basic, like, what's the word I'm looking for? They're basically those clauses, those articles are, basically states being able to choose their electors, and yeah, and how many senators and stuff like that. Regulation of that. Actually, what was that Article 1 again? Sorry. Yeah. So that's basically, the first, Article 1 is, they, states have the ability to choose time, place, and manner for elections of senator of Congress. Um, and then Article 2, Clause 2 was choosing of electors, basically. So yeah. So basically, what they're saying is that's an example of what the that Congress delegate, or the federal government delegate um the power to elect and choose the people of Congress. It's what they're basically referring to. Um, but nothing in the clauses, as they stated, authorize states to enforce Section 3. So it's just an example of how a state has power over a federal office, but that it also doesn't mean, it's just an example of states having a power over the federal office, i.e., time, place, manner of when they hold elections, etc. Let's see. The text of Section 3 reinforce these conclusions. Its first sentence empowers Congress to remove any Section 3 disability by 2/3 of vote of each House. The text imposes no limits on that power, and Congress may exercise it at any time, as respondents concede. See brief for respondents 50. In fact, historically, Congress sometimes exercises this amnesty power post election to ensure that some of the people's chosen candidates can take office. But if the state were free to enforce Section 3 by barring candidates from running in the first place, Congress would be forced to exercise its disability removal before voting begins if it wishes for its decision to have any effect on the current election cycle. And these are, let's see. So these are just little notes that kind of give some more. Oh, look, I looked this up for no reason. Yeah. So, yeah. Okay, there's that. Okay. So, this is just an example of when Congress removed a Section 3 disability to incoming congressman or senator. Interesting. Perhaps a state may burden congressional authority in such a way when it exercises its exclusive sovereign power over its own state offices. Taylor, uh, 178 U.S. at 571. But it is impossible to suppose that the Constitution, affirmatively delegates to the states the authority to impose such a burden on Congress power with respect to candidates for federal office. C.F. McCulloch versus Maryland. Wheat, for wheat. States have no power to retard, impede, burden, or in any manner control the operations of the constitutional laws enacted by Congress, nor have the respondents identified any tradition of the state enforcement of Section 3 against federal office holders or candidates in the years following ratifications of the 14th Amendment. Such a lack of historical precedent is generally a telling indication of a severe constitutional problem with this asserted power. United States versus Texas, quoting free enterprise funding versus public company accounting oversight bid. And it is an especially telling sign here because, as noted, states did disqualify persons from holding state offices following ratifications of the 14th Amendment. What patterns of disqualifications with respect to state, but not federal offices, providing persuasive evidence of general understanding that states lack enforcement power with respect to latter. Yeah, so there's been a bunch of times where states have disqualified persons from holding state offices under the 14th Amendment provision, but there's none of states disqualifying a person from running or holding federal office. And that's very telling. U.S. term limits, 514. So then they add that there was an instance, one small instance, but so we'll read that. We are aware of just one example of state enforcement against a would-be federal officer. In 1868, the governor of Georgia refused to commission John Christie, who won the most votes in a congressional election, because the governor's view, Section 3, made Christie ineligible to serve. But the governor's determination was not final. A committee of the House reviewed Christie's qualifications itself and recommended that he not be served. The full House never acted on the matter, and Christie was never seated. See 1A Hins, Proceedings of House of Representatives, Section 459, pages 470 to 472, 1907. Instead, it is Congress that has long given effect to Section 3 with respect to would-be or existing federal officers. Shortly after the ratification of the amendment, Congress enacted the Enforcement Act of 1870. That act authorized federal district attorneys to bring civil actions in federal court to remove anyone holding non-legislative office, federal or state, in violation of Section 3, and made holding or attempting to hold office in violation of Section 3 a federal crime. Section 14, 15, 16, Stat 143-144, repealed 35 Stat 1153, 1154, 62 Stat 992-993. In the years following ratification, the House and Senate exercised their unique power under Article 1 to adjudicate challenges contending that certain prospects or sitting members could not take or retain their seats due to Section 3. See Article 1, Section 5, Clause 1, 2. 1A Hins, Proceedings of the House of Representatives, Section 459-463, paper pages 470 to 486, 1907. Confiscation Act of 1862, which predates Section 3, effectively provided an additional procedure for enforcing disqualification. That law made engaging in insurrection or rebellion, among other acts, a federal crime punishable by disqualification from holding office under the United States. See Section 2, 3, 12, Stat 590. A successor to those provisions remain on the books of the C 18 U.S. Code, Section 2383. Whew, a lot of mouthful. Sustenance. That law may, moreover, permitting state enforcement of Section 3 against federal office holders and candidates would raise serious questions about the scope of that power. Section 5 limits congressional legislation enforced in Section 3 because Section 5 is strictly remedial. City of Bourne 521 U.S. at 520. To comply with that legislation, Congress must tailor its legislative scheme to remedy, or preventing the specific conduct that conduct the relevant provision prohibits. Florida Prepaid Post-Secondary Ed Expense Bin versus College Savings Bank 527 U.S. 627 639 1999. Section 3. Unlike other provisions of the 14th Amendment, prescribes conduct of individual, it bars persons from holding office after taking a qualifying oath and then engaging in insurrection or rebellion. Nothing more. Any congressional legislation enforcing Section 3 must, like the Enforcement Act of 1870 and Section 2383, reflect congruence and probability or proportionality between preventing or remedying the conduct and the means adopted to that end. City of Bourne 527 U.S. at 520. Either we nor the respondents are aware of any legislation by Congress to enforce Section 3, see ter of oral arg. I assume that's transcript of oral argument 1, 2, 3. Any state enforcement of Section 3 against federal officer holders and candidates would though, would not derive from Section 5, which confers power only on the Congress. As a result, such state enforcement might be argued to sweep more broadly than congressional enforcement could under our proceedings. But the notion that that the Constitution grants the states free reign that then Congress to decide how Section 3 should be enforced with respect to federal office is simply implausible. Finally, state enforcement of Section 3 with respect to the presidency would raise heightened concerns. In the context of presidential elections, state imposed restrictions implicate a unique important national interest. Anderson versus Selbreeze. Footnote omitted. By state resolution of the question, whether Section 3 bars a candidate for presidency from serving would be quite unlikely to yield a uniform answer consistent with the basic principle that the president represents all the voters in the nation. ID at 795, emphasis added. Conflicting state outcome concerns that the same candidate could result not just from differing views of the merits, but from variations in state law governing the proceedings that are necessary to make Section 3 disqualification determination. Some states might allow a Section 3 challenge to succeed based on preponderance of the evidence, while others might require a heightened showing. So what that means basically there is like the standard in which they would disqualify a candidate would vary state to state. Some state would use a civil standard, preponderance of evidence, 51, while other states might actually use a decent standard, which would be the criminal one, which would mean beyond beyond reasonable doubt. So that basically it means like someone could be disqualified in one state based on preponderance of the evidence, while in another state they wouldn't be disqualified because that state requires beyond a reasonable doubt, and because that's not consistent, it wouldn't make sense. Like you couldn't it wouldn't be this is the disqualification. Here's the line. If they made it, then everyone has to drop them. It would be only in some states they could drop, while in other states they might not be. Which in the states that have a very slow threshold would affect states that have very high threshold. Certain evidence, like the congressional report on which the lower court relied here, would be admissible in some states, but inadmissible hearsay in others. Disqualification might be possible only through criminal prosecution, as opposed to expedited civil proceedings in particular states. Indeed, in some states, unlike Colorado or Maine, where the Secretary of State recently issued an order excluding former president from the primary ballot, procedures for excluding an ineligible candidate from the ballot may not exist at all. The result could well be that a single candidate would be declared ineligible in some states, but not others, based on the same conduct, perhaps even the same factual record. The patchwork that would likely result from state enforcement would sever the direct link that farmers found so critical between the national government and the people of the United States as a whole. U.S. term limits 514 U.S. at 822. But in a presidential election, the impact of the votes cast in each state is affected by the votes cast, or in this case, the votes not allowed to be cast. For the various candidates in other states, Anderson 460 U.S. at 795. An evolving electoral map could dramatically change the behavior of voters, parties, and states across the country in different ways and at different times. This disruption would be all more acute and could nullify the votes of millions and change the election results if Section 3 enforcements were attempted by the nation after the nation had voted. Nothing in the Constitution requires that we endure such chaos, arriving at any time or different times up to or beyond the inauguration. For the reasons given, responsibility for enforcing Section 3 against federal office holders and candidates rests with Congress and not the states. Judgment of the Colorado Supreme Court, therefore, cannot stand. All 9 members of the court agree with that result. Our colleagues write separately, further agreeing with many of the reasons this opinion provides for reaching. See Post Part 1, Joint Opinion of Sotomayor, Kagan, and Jackson, JJ. See also Post P1, Opinion of Barrett, J. So far as we can tell, they object only to our taking into account the distinctive way Section 3 works, and that the fact that Section 5 vests in Congress the power to enforce. These are not the only reasons a state lacks power to enforce this particular constitutional provision with respect to federal office, but they are important ones, and it is the combination of all reasons set forth in this opinion, not as some of our colleagues would have it, just one particular rationale that resolves this case. In our view, each of these reasons is necessary to provide a complete explanation for the judgment the court unanimously reached. The judgment of the Colorado Supreme Court is reversed. The mandate shall issue forthwith. It is so ordered. Whew! There we go. All right, so these are the dissents. These are, basically the, somewhat disagreements. Oh, sorry, that was a mouthful. It took almost an hour for me to read those, those few pages. I got 6 more pages to go. We will. Let's see. I'm just looking real quick. Okay, so we'll read the opinions, and then it looks like we're not going to get to anything else, which is fine. I preface that. But we will definitely still watch that video. That video being the greatest campaign edit of all time, and then I'll get to the rest of the stuff later. Not a big deal. It is what it is. I was kind of expecting this. So here is the opinion of Justice Barrett. Justice Barrett, concurring in part and concurring in the judgment, I join Part 1 and 2B of the court's opinion. I agree that states lack the power to enforce Section 3 against the president candidate. The principle is sufficient to resolve this case, and I would decide no more than that. This suit was brought by Colorado voters under state law in state court, and it does not require us to address the complication question whether federal legislation is the exclusive vehicle through Section 3 can be enforced. The majority choice of a different path leaves the remaining justice with a choice of how to respond. In my judgment, this is not the time to amplify disagreement with stringency. The court has settled a political charge issue in the vital season of the presidential election, particularly in this circumstance. Writings on the court should turn the national temperature down, not up. For present purpose, our differences are far less important than our unanimity. All 9 justices agree on the outcome of this case. That is the message Americans should take home. Okay, so that was her opinion. Like, hey, I agree with this, eh? All right, so this is Justice Sotomayor, Justice Kagan, and Justice Jackson. I think these are the liberals. Yeah, these are the liberals. These are the women. So let's see what they have to say. If it is not necessary to decide more to dispose of a case, when it is necessary not to decide more. Dobbs versus Jackson, Women Health Organization. Okay, whatever. That fundamental principle of judicial restraint is particularly as old as our republic. This court is authorized to say what the law is only because those who apply a rule to particular cases must of necessity expound and interpret that rule. Madbury versus Madison, one Cranch. Today, the court departs with the vital principle deciding not just this case, but challenges that might arise in future. In this case, the court must decide whether Colorado may keep a president off, may keep a president candidate off the ballot on the grounds that he is an oath breaker, insurrectionist, and thus disqualified from holding federal office under Section 3 of the 14th Amendment. Allowing Colorado to do so would, we agree, create a chaotic state by state patchwork at odds with our nation's federalism principle. That is enough to resolve this case. Yet the majority goes further, even though all 9 just members of the court agree that this independent and sufficient rationale resolves this case. 5 justices go on. They decide novel constitutional questions to insulate this court, petitioner from further controversy. ANT at 13. Although only an individual state action is at issue here, the majority opines on which federal actors can enforce Section 3 and how they must do so. The majority announced that a disqualification for insurrection can occur only when Congress enacts a particular kind of legislation pursuant to Section 5 of the 14th Amendment. In doing so, the majority shuts down the door on other potential means of federal enforcement. We cannot join in an opinion that decides momentous and difficult issues unnecessarily, and therefore concur only in the judgment. Our Constitution leaves some questions to the states while committing others to the federal government. Federalism principles embedded in the constitutional structure decides this case. States cannot use their control over the ballot to undermine the national government. U.S. Term Limits, Inc. versus Thornton. The danger is even greater in the context of a presidential election. Anderson versus Selbreeze. State restrictions in the context implicate a unique, important national interest extended beyond the state's own borders. I bid. No doubt, states have significant authority over presidential electors and, in turn, presidential elections. Scheifele versus Washington. That power, however, is limited by other constitutional constraints, including federalism principles, ID at 58.9. The majority rests on such principles when it explains why Colorado cannot take petitioner off the ballot. Petitioner's Trump, if you guys weren't aware. State by state resolution of the questions, whether Section 3 bars a particular candidate for our president from serving, the majority explains would be quite unlikely to yield a uniform answer consistent with the principle that the president represents all voters in the nation. It's especially so, the majority adds, because different states can reach conflicting outcomes concerning the same candidate, not just from differing views of the merit, but from variations in state law governing the proceedings to enforce Section 3. The contrary conclusion that a handful of officials in a few states could decide the nation's next president would be especially surprising with respect to Section 3. The Reconstruction Amendment, which were specifically designed as an expansion of federal power and intrusion on state sovereignty, City of Rome versus United States. Section 3 marked the first time the Constitution placed substantive limits on state authority to choose its own officials. Given that context, it would defy logic for Section 3 to give state new power to determine who may hold presidency. It would be incongruent to read this particular amendment as granting the state the power, silently no less, to disqualify a candidate for federal office. That provides a secure, sufficient basis to resolve this case. To allow Colorado to take the president candidate off the ballot under Section 3 would imperil the farmers' vision. Framers. I keep saying farmers. I realize that actually means framers. Framers' vision of a federal government directly responsible to the people. U.S. term limits. The court should have started and ended its opinion there with this conclusion. Yet the court continues on to resolve questions not before us. That happens all the time. In a case involving no federal action whatsoever, the court opines on how federal enforcement of Section 3 must proceed. Congress, the majority says, must enact legislation under Section 5 prescribing the procedure to ascertain what particular individual should be disqualified. These musings are inadequately supported as they are gratuitous. To start, nothing in Section 3 text supports the majority's view on how federal disqualification efforts must operate. Section 3 states simply that no person shall hold certain positions and office if they are oath breakers and insurrectionists. Amendment 14. Nothing in the unequivocal bar suggests that implementing legislation enacted under Section 5 is critical, or for that matter, what the words mean in this context. In fact, the text cut the opposite way. Section 3 provides that when an oathbreaker and insurrection is disqualified, Congress may, by a vote of 2/3 of each, remove such disability. It's hard to understand why the Constitution would require a Congress supermajority to remove a disqualification if a simple majority could nullify Section 3 operations by repealing or declining to pass implementing legislation. Even petitioner's lawyer acknowledged the tension in Section 3 that the majority view creates. See transcript of oral argument 31. But then who determines who's an oathbreaker and insurrectionist? That's kind of a big question. You can't just, oh, this person, like they're doing this right now. Trump is an insurrectionist and oathbreaker. Okay. But he hasn't been charged with insurrection. Okay. He hasn't been charged with it. And he hasn't also hasn't even been convicted of insurrection. So who determines who's an insurrectionist? It's a question that needs to be determined. And the thing is one Congress, okay, like it could be very well that the supermajority in one session determines, hey, this person is disqualified under this on the of the 16th of Section 3 of the 14th. So this person here, like say the Democrats hold the majority of House and of Congress and House terribleness. The majority would determine Donald Trump is disqualified under the 14th Amendment. Okay, and then an election comes. That majority is no longer here; they're gone, and now a new majority of Republicans have come in. And Trump's like, "Look, I want to run for office. Would you remove my disqualification?" Or sorry, I'm going to, I'm about to hold office. I won the election. Will you remove my disqualification? And Congress can vote by 2/3. Yes. So this actually makes complete sense if you really think about it, because Congress is ever shifting. So while one may, let me back up. First off, you need a way to determine who is disqualified based on Section 3. You need a way to determine that. Just saying oath-breaking insurrectionist doesn't really answer that question, because who determines this? Is it just because a bunch of people say that? There has to be a way to determine that. Okay. And, is it a standard by civil, or is it a criminal standard that you must find someone, an insurrectionist, to disqualify them under the 14th Amendment? That is an answer that needs to be, that's something that needs to be determined. And again, like I pointed out, let's say Democrats hold the House and the Senate, and they decide Trump is disqualified based on Section 3 of the 14th Amendment. And then, 2 years go by, and election happens, and now Republicans hold the majority of the Congress and Senate. And Trump goes, hey, I'm running for office. I won office. I was elected. I need you to remove my disability from holding office. And Congress can go, all right, well, we hold the majority. Now we will remove this disability. So it makes perfect sense. Or even, let's not even go with presidency, because I don't really think the presidency applies in Section 3. Let's just say it was a Congress person. And they, let's say, again, one of the Republican Congress people, they get, people keep calling them insurrectionists, whatever. And now the Democrats hold, the majority, and they disqualified this person, remove him from office for being an insurrectionist. And then 2 years later, hey, well, now the Republicans hold it again. So now it's our turn, and now we're going to remove that disqualification. So it actually makes perfect sense. Similarly, nothing else in the rest of the 14th Amendment supports the majority's view. Section 5 gives Congress the power to enforce the amendment by appropriate legislation. Remedial legislation of any kind, however, is not required. All the Reconstruction's amendments, including due process and equal protection guarantees and prohibition of slavery are self-executing, meaning they do not depend on legislation. City of Bourne versus Flores, see civil rights case. Similarly, other constitutional rules, disqualification, like the two-term limits of on the presidency, do not require impending legislation. See Article 2, Section 1, Clause 5, Presidential Qualifications, Amendment 22, Presidential Term Limits. Nor does the majority suggest otherwise. It simply creates a special rule for insurrection disability in Section 3. The majority is left with with next to no support for its requirements that a Section 3 disqualifications can occur only pursuant to legislation enacting for that purpose. Cites Griffin case, but that is not precedent. That is not a precedential lower court opinion by a single justice in his capacity as a circuit judge. See whatever annotation, I think, of 5 at 5. Once again, even petitioner's lawyer distanced themselves from fully embracing this case as a prohibitive of Section 3, meaning see transcript of oral argument 35-36. The majority also cites Senator Trumbull statements that Section 3 provides no means of enforcing itself. The majority, however, neglects to mention that the Senate views that it is the 14th Amendment that prevents a person from holding office, with the proposed legislation simply affording a more effective and speedy remedy for effecting disqualifications. Okay? Ultimately under the guise of providing a more complete explanation for that judgment, the majority resolves many unsettled questions about Section 3. It foreclosed judicial enforcement of that provision such as might occur when a party is prosecuted by an insurrectionist and raises defense on that score. The majority further holds that any legislation to enforce the provision must prescribe certain procedures tailored to Section 3, ruling out enforcement under general federal statutes requiring the government to comply with the law. By resolving this and other questions, the majority attempts to insulate all alleged insurrectionists from future challenges to their holding federal office. Not really. All it says is you need a procedure, and Congress is the way you make that procedure to determine someone is disqualified. Because again, it just goes by state by state. Or sorry, that's not what I mean. But it doesn't really insulate all alleged. Again, that's alleged insurrectionists. When the 14th Amendment was made, they were definitely the people that were fell under this were definitely insurrectionists. There wasn't like a clash of opinions. One people saying they were insurrectionists, other people weren't. No, we all knew because they lost the war. They fought against the Union, and they left the Union, and they broke their oath. It was very clear. Now during this thing, people like Democrats, leftists, they keep calling them insurrectionists, but no one's been charged with an insurrection. No one's been convicted of insurrection. And honestly, it was an insurrection because, who the fuck tries to overthrow a government without any guns? Tries to overthrow a government 14 days before the transfer of power, no firearms, no supply lines, no hostages, no way to prevent any certification of the electoral votes. It doesn't make any sense. So it doesn't insulate all alleged insurrectionists. It just says you need a procedure, and Congress is that way to, find that procedure. What it does today, the Congress should have left undone. Bush versus Gore. The court today needs to resolve only a single question: whether an individual state may keep a presidential candidate found to have engaged in insurrection off its ballot. That's not really correct because the Colorado used a civil standard, I believe, to find that Trump engaged in insurrection, but just because they use a civil standard, this was again what they talked about. One used the Colorado state used a civil standard, while other states may use a criminal standard. So it doesn't make sense. You can't say he's engaged in insurrection if all you used was a civil standard. You have to have some sort of criminal standard because insurrection is a civil matter or is a criminal matter. The majority resolves much more than the case before us. Although federal enforcement of Section 3 is in no way an issue, the majority announces novel rules for how that enforcement must operate. It reaches out to decide Section 3 questions not before us and to foreclose future efforts to disqualify a presidential candidate under that provision. In a sensitive case crying for judicial restraint, it abandons that course. Okay. It's Section 3 serves an important, though rarely needed, role in our democracy. The American people have the power to vote for and elect candidates for national office. That is great and glorious thing. The people who drafted and ratified the 14th Amendment, however, had witnessed an insurrection and rebellion to defend slavery. Section 3. That insurrection and impossible future insurrections could not return to prominent roles. Today, the majority goes beyond the necessities of this case to limit how Section 3 can bar an oath breaking insurrectionists from becoming president. Although we agree that Colorado cannot enforce Section 3, we protest the majority's efforts to use this case to defend the limits of federal enforcement of that precision because we only decided because we would only decide only the issue before us. We concur only in the judgment. Yeah, but why? Who determines that someone is an oath-breaking insurrectionist? That's the question before you: is who determines this? And there's been no way an actual determination of this fact. They call Trump an insurrectionist and the oath breaker and all that stuff, but is he? No one has determined that. No court has determined that because no law, because he hasn't been convicted of it. It would be, he'd have to be convicted of a crime, in my opinion, to actually reach Section 3. And when the 14th Amendment was ratified, guess what? There was it was pretty clear. There wasn't a question of what were the insurrections. South lost, the North won. Therefore, they were the insurrectionists. If it was reversed, the South won and the North lost, the North would have been insurrectionists. Simple as that. All right, so that's it for the statement. I hope you guys enjoyed that. I read that whole fucking thing, and that took about an hour. Figured it would. So instead of doing all the other things I planned on, we will watch this great political ad. This is by far the greatest political ad of all times. I don't care what you say. All right, let's watch.
Democrats like to say that no one needs an AR-15 for self-defense, that no one could possibly need all 30 rounds. But when this rifle is the only thing standing between your family and a dozen angry Democrats in Klan hoods, you just might need that semi-automatic and all 30 rounds.
So look at that. Come on. That is the greatest political ad. It's a black guy against a bunch of Klansmen. Jerome, what's this fucker's name? What state is he in? Jerome Davison. Okay, he's an American football player. Cool. Not really what I care for, honestly. I just want to know what state he's in. I'm sure that's a clue right there, in his O, but I don't know. Okay, looks like Arizona? No. Yeah, okay. Okay, so Arizona. So if you're in Arizona, you need to vote for this black man, all right? Because that was by far the greatest political ad of all time. It's a black guy versus against a bunch of racists in Klan hoods. That was awesome. You can't hate that. That was a great political ad. I don't care what you say. That was a great political ad. All right. I hope you guys enjoyed this video. I hope you enjoyed listening to me talk about the variety. Sorry. Changing my title up. Anyways, hope you guys enjoyed the video. Hope you guys enjoyed listening to me read that entire opinion. Yeah, it's the right decision, and the descendant justices that make no sense, because obviously. Now, I agree with the fact that it wasn't a necessary thing for them to answer, but it was the right decision regardless, and their answers make complete sense if you actually think about it, and not about this whole like they decided something I don't agree with. It was a good decision. It was the correct decision. It makes perfect sense. Yeah. Hope you guys enjoyed the video. Make sure you like and subscribe. Give me a follow, of course, if you're on Rumble. Rumble.com/withghost. Best place in the world. But yeah, I hope you all have a good day. Peace out and see you later.